It's been a very stressful day for the families. We're obviously relieved by the decision. We don't take anything for granted. It was a very difficult process for the families. It was very difficult for the families to hear Paul Bernardo's evidence, if you want to call it that, his explanations for his crimes. We're certainly also relieved not just that day in full parole was denied, but that the parole board, with obviously reasons to follow, have reaffirmed the dangerous offender designation that was found by Associate Chief Justice Patrick Lesage 25 years ago. And so that's very important to us. It's very important to the family that people understand that not all people who have been convicted of first-degree murder and sentenced to life imprisonment are also declared dangerous offenders. And so the fact that Paul Bernardo is also been designated a dangerous offender, and that has been upheld today, is very important, because we do believe there's a qualitative difference between the considerations that the parole board gives when considering whether or not to relieve someone from the dangerous offender designation, as well as whether to relieve them from the consequences of the life sentence. So in that regard, we're very pleased. There are issues that I think have arisen today, which you may have identified, and it's something that we have before the courts. It's the parole board itself, and I think I think it's important to say that we were very impressed and pleased by the hard work of the parole board panels. I think you can see that they really rolled up their sleeves. They took this very seriously. They obviously put in a lot of time and effort to understand the file, and from our point of view, made the right decision. Having said that, what is disturbing to us is that the entire criminal justice system, and indeed civil justice system, is completely transparent. For all you in the media who were with us 25 years ago and attended the dangerous offender sentencing, for example, or hearing, and the trial itself, everything was transparent. So why all of a sudden we get to the other end of the criminal justice system and everything is not transparent? And so it struck us that when Bernardo talked about a certain doctor and a certain assessment, we only know what we're hearing at the hearing itself. That would never be permitted in a criminal trial or a civil trial. And there's another case of which the Frenches and the Mohafis are involved in, dealing with another offender by the name of Craig Monroe, who murdered Police Constable Michael Sweet in 1980. And in that case, we're before the federal court on a very important, what we believe to be freedom of the press, freedom of information case. And as I said, the Frenches and the Mohafis have joined in on that case for the court to adjudicate that the parole system should be as transparent as the criminal justice system trial is, so that all of us should have the benefit of the reports that everybody's relying upon, and what Paul Bernardo attempts to rely upon to be paroled. And the reason why we're not entitled to it is because of what we're told is Paul Bernardo's privacy rights. And there's nothing private about this. This is a public hearing. Paul Bernardo seeks a public disposition, a public remedy, to be relieved from the consequences of his dangerous offender designation, to be relieved from the consequences of his life sentence, and to be reintegrated back into the community, where the ultimate test for the parole board is public safety. So every aspect of this is public, and I don't accept at all that neither the victims nor the public at large, the media, is not entitled to this information because of the offender's privacy rights. And that's the case that's, as I say, is presently before the Federal Court of Canada, and we'll see how the court adjudicates in that case. If Paul Bernardo wants his privacy rights, then he doesn't have to seek a public remedy, and he can stay in jail. But the moment that Paul Bernardo or Craig Monroe or any other offender who's been convicted of first-degree murder and sentenced to life imprisonment, The moment they seek that public remedy, their privacy rights are waived. And finally, I would say that even under the privacy legislation, there is a balancing that goes on when you make an access for information request between the privacy interests of the offender and the public interest. And I can tell you in the case of Paul Bernardo and in Craig Monroe, both corrections and parole have held in favor of the privacy interests of Paul Bernardo and Craig Monroe. So, I hope that by you viewing the hearing itself, I hope that you had questions yourself when you hear references to these doctors and these reports or incidences or whatever, and we just have to take everybody's word for it. And that's just not the way our system works. So while we're relieved by the decision, we're pleased by the decision, I think that we have to examine the whole parole system a little bit more in terms of its transparency.